going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Happy Friday, the end of the week. I hope everyone's doing well. I hope you guys had a great week. We got a good one. All right, I've got a good one. We've got a good one. Apologize for my rambling. I took an impromptu nap on accident while I was compiling this video. Let's say that. And I woke up about 30 minutes ago freaking out because I didn't post anything yet. All right, but I'm here. We're there. We're here. We're there. Everywhere. All right, let's go. We've got a couple sovereign citizens. We've got a couple really smart people. All right. Some of these videos have been played on other channels, but hey, I get the same content everyone else does at times. Sometimes I get content that no one else gets. There's a mix in between. But, I still share the good ones. Anyways, before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Use a table and have a seat. Just have a seat. I'm not asking you to say anything yet. All right, just have a seat. So, a couple of folks not here. We'll take up. So we're going to take up first Mr. Brown. We've got Ms. Willman here on Zoom. This is case 24-188. And so let me just get you both put under oath here. There might be a couple of questions. So Ms. Willman, start with Ms. William. Ms. Willman, can you raise your right hand? And Ms. Willman, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
All right. And Mr. Brown, do you swear to tell the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Okay. So, Ms. Willman, are you able to hear Mr. Brown?
I can, yes.
Okay, that red lighted thing doesn't amplify, but it collects, it'll allow Ms. Willman and the record to hear you. So just so you know what that is.
Thank you.
All right, so we're on case 24-188, and I see, Ms. William, you were served. I also see that Thurston County Superior Court has taken a defamation case from some information that was filed here. And as recently as April 15th, there was a denial of your request, Mr. Brown, by this court for an order against Ms. Willman. And so I looked at previous information that was filed, and I looked at the information that was filed for this case. And there isn't anything alleged, Mr. Brown, from you that is different or in addition to April 15th in this petition.
Your Honor,
So,
sorry.
is there anything else?
Is there Officer Lee's Desmond here, 1P85? He said he's gonna help testify on my character.
It's up to you to have people come to court on your behalf, just as it's up to Ms. Willman to do that. So
I understand, Your Honor. I did talk to
ask them
Officer.
to be here?
Yes, I did. He said he was going to be here.
Did you put him under subpoena or ask the court to send a subpoena? I don't see that you asked the court to do that.
He just gave me his word. I saw him when he was going to Ido Avery's house to serve him the petition. And on the way back, I asked him, I told him that the court is on the 17th at 9 a.m. If he could please be here. Since he's not here, I would like to ask a continuum for next time so he has a chance to be here so I can subpoena him.
And what do you expect him to say?
To talk about the issues that's been going on for the past 2 years and how
anything from April 25th or April 15th when you were last before this court?
Yes, Your Honor, I've had a letter received in my mail that I believe is from Lewis Willman and her associates.
Was that what you provided in your exhibits?
The recent ones. I had 150 other pages that I don't know why I was denied, but I did have a huge list of
so let me get you to answer my question.
I'm sorry, Ms.
Since April 15th, when you were before this court last and the court said, no, you don't get an order against Ms. Willman, I'm going forward from April 15th and looking at what you filed in this petition alone. And you're referring to, you got another letter that you think is from Ms. Willman and you think that's unlawful harassment. Is that right?
Your Honor, yes, Your Honor.
Okay.
And
And you filed that, and that's what I'm looking at in your exhibits. That's what you're saying
yes,
is the new information.
can I explain why I feel like the letters are derived from her and the situation at large, please?
Well,
if
not the situation at large. I'm
Yes.
asking you to narrow your information from April 15th forward, because we've already had a hearing on everything previously. I understand that the court can look back, and I did look back and I reviewed all of what was reviewed previously by the judge, because, you know, sometimes these courts of conducts require that look back, but there's already been a decision based on previous information, and it was found that there was not.
I disagree, Ali. You know, if you're eating crayons, then, you know, that is space saving because they're small, they fit in your pocket, and it's a good snack to have on the road. Yeah, I don't do that. Don't do that. That was a joke. No one eat crayons. No one eat crayons. If you guys know where the joke came from, you know where the joke came from.
Course of conduct, there was not unlawful harassment committed by Ms. Willman.
Wow.
So I'm talking April 15th going forward,
Yes.
and what you filed isn't providing the court any information.
The
support that.
letters that were sent, this is why I was trying to have the sheriff here, because I knew I couldn't resubmit the papers that were here. But there is a long history of, she emailed.
I understand. I've reviewed the previous petitions,
I know, I'm sorry, miss.
and we're
I
talking
understand.
April 15th going forward
It's
now.
a letter that was sent that talks about things that's directly related to the case that you wouldn't have any knowledge of unless you're watching the court case in itself. That doesn't seem likely.
This court case or the defamation case?
The one with Ido Avery, that I had a petition against him.
Right,
If you
and I've
notice, on
reviewed
May
that.
17th, she sent a letter was sent at that was sent from Tacoma that
Gene, I hope you have an incredibly safe drive home, and thank you so much for listening on your way home. Happy Friday.
if you would read the letter, you'd see inside of there. She
I'm
delivered the
looking at your
papers at,
exhibits,
oh,
and
sorry.
so
she
direct me here. Something to Megan Lee Russell, member Prostitute Association, that's the return address to Grace Monson, member Prostitution Association. So is that what I'm supposed to do? Figure something from? Tell me what that.
Yes, if you
Applies.
notice in there, that little picture on the upper right-hand side of a man pulling his pants down, that was attached to a letter that was in the last petition that was most likely sent from my neighbor saying, stay away from outside the easement. And with that paper was another one that said, court case with Lewis Willman on there. It was delivered on the same day on that there was a court date in May, I believe. And so I'm just really nervous about this.
Well,
And
right.
in it, if you notice, a lot of the language in there is very derived of somebody who would be personal knowledge and knowing about things that are happening and direct harassment towards me. I've never had any issues with harassment until I received till Louis Millman has stepped into my life 2 years ago. And since April 15th as well, I've had a local bar, which I don't even drink. I haven't been sober 11 years. And a lot of the language in there is saying I'm a violent person. I've never had anything violent on my record.
So you say something sent to a third party at a bar or a tavern?
Is that not the same thing? It's 313 Sussex. I haven't
Okay,
drinking
so a
lot
letter was sent there. How do you know that?
because it had my return address and I have a letter at my house. I'm ready to put that into for a PI to get a DNA test done on it. Have you noticed where it's sent from? It's sent from
So
Tacoma.
Mr. Brown, I'm not going to go forward any more with.
Is there any way that
nope,
it can
stop.
continue?
No,
I didn't even
I'm
say
not,
my
there is
side.
nothing that you're going to present to the court that hasn't already been presented. You've presented all of your information for this petition under 24-188. I've reviewed all of that. As I said, I've gone back because I noticed that there was a hearing April 15th that denied your request. Don't interrupt me. And I see also that Superior Court has taken some jurisdiction. I don't know what's going on there, or if it continues on that case. But in this situation, you have provided nothing to the court that is in addition or different than what was already decided April 15th. So
My case will be
don't
looked
interrupt
at
me,
on the
Mr. Brown.
15th.
Do
I know.
not interrupt me.
Okay.
I'm ruling.
Crayons and drugs. Crayons and drugs. Then you can live this guy's delusions. All right. I need to catch up real quick. Bad Scooter. Bad Scooter, what's up, buddy? Good to see you. Thank you so much for the 5 months. Thank you. That is awesome, man. And Toby for the 2 months. Thank you so much. Hi, Colin and folks. Thank God. Thank goodness it's Friday. TGIF. Absolutely. Absolutely. Thank you so much, Toby. Blaine, thank you so much for the $5 super sticker. I appreciate it. All right. Yeah. You gotta pause it through this one every so often. Otherwise, you're gonna start believing what this guy is, I don't want you guys drinking the Kool-Aid. So we gotta pause it, separate reality from whatever this guy's drinking.
As to this case, 24-188, denying your request for any order against Ms. Willman. And that's the end of it, is you haven't proven to a legal standard unlawful harassment committed by Ms. Willman against you.
I have 150 pages of the documents. I
And
sent
April
you last time.
15th, there was a denial and a consideration of all the information
But
that you
if-
filed
if
then
I
and
allowed
nothing
to
new.
go and
Not
present
arguing
my
with you,
case-
Mr. Brown, stop.
I'm not.
No argument. I'm
Okay.
done. I've ruled on this case. We
But I
have
haven't
two
gone
others to
present
talk
my
about.
case,
We have
though.
two
I haven't gone
others to
speak
talk
about it.
about.
And it's been a lot
So
of
we're gonna
harassment
move
from
on
this
to the
person.
other two where
There's
people.
no.
Okay, he has 2 phones. He has 2 cell phones in his little folder thing that he keeps closing. That's point one I want to say. If you're double phoning it and one of them's not a work phone, then yeah, you're paranoid. You are paranoid. So, I'm not saying that one of his phones isn't a work phone, but if it is, why are you having it on the table? You don't need it on the table. You only need one phone. You don't really need any phones if you come prepared. Also, the lady at the bottom of the screen is who he's afraid of. I just want to throw that out there. She might be the most evil person ever, but he is a young man. Just ignore her. She sent you a letter. Okay. She's sending you snail mail. Oh man, this is harassment, and I am terrified of my existence. Just go away. Go away, man. Just go away.
Why
Way they
not?
can continue.
Mr.
I had
Brown?
a sheriff who's
No.
going to come here and
No.
testify. on my
No,
behalf.
there is no basis
I've
to
had bullets left in
continue.
my mailbox.
No good cause. There's nothing that you've presented.
The fact
that
that it's letters and she's an
witness will
elderly
present
lady
anything
isn't
other
enough
than-
of like connective.
Mr. Brown, you've
evidence.
got to stop talking.
But I
You've
can't
got to
finish my
stop
own
talking so I
sentence.
can rule, and then we can move on to the other
Your
cases.
rule is your rule in her favor. I get it.
Finding there's no good cause to continue this case as your witness is not present by 9:30. You did not put them under subpoena. There's no good reason to believe why they're not here other than that they didn't know about this or don't want to be here. And you haven't provided any information for the court to find.
All right, I didn't want to pause it so quick right after I just did. First off, Terry, this is not the sovereign citizen. I think the next 2 cases I have are sovereign citizens. This one is not. So this is just, I call this the series Sob Sits and Idiots. This is one of the idiot parts of the Sob Sits, but he's not a Sob Sit. Also, Big In, thank you so much for the raid, Big In. Thank you, I appreciate it, bud. Hope you had a great night. I actually took an impromptu nap while my video was compiling for tonight, so I was not in your chat tonight, and I am sad about it, but I will check out your video after mine. I hope you had a great night. I hope you had a good showing for your video, and yeah, have a great weekend, buddy. Thank you so much for the raid.
Good God,
I'm
good
able to
God.
speak my
Good
case.
cause that this person will provide anything different to your petition, and your petition is wholly insufficient for the court to issue any kind of order against Ms. Willman,
I also haven't been able to present my
given the
case.
fact that the court has reviewed all of that information on April 15th and made this decision. I
Like,
looked for
There's
anything
no way
after
all that
April
you guys
15th.
looked through 150 pages worth of the paperwork and saw that she was not involved with direct
So,
orders. She was
We'll move
messaging
on
the
to the
person who
next
stole my animals.
case,
When my
which
animals
is
were stolen,
with this
miss,
24-189.
messaging the
Are you
people
ready
who
to
were
move
stolen.
on?
Can I
You
just
gonna move
please-
on
can I-
with me?
Can I say my last piece, please?
No, we're gonna move on. I've made
She
my
was
ruling.
messaging the person who stole
No,
my
Mr.
animals.
Brown, you're not listening. We have 2 other cases to deal with. Stay seated. So you've also asked for, so Ms. Willman, you can be on your way if you'd like. That's the end of the hearing. There is no order issued. I can't hear you, Ms. Willman. You've muted yourself.
I would just like to mention that on Friday, this last Friday, the 14th.
So I don't need any testimony from
Okay.
you, Ms. Willman. I've made my decision. The court will
Perfect.
not be issuing an order. There's not a basis.
Yeah, and that was denied as well, Lewis.
Okay. So,
You lost that case.
Mr. Brown. So you can be on your way, Ms. Willman. If you'd like to stay, you can
I
stay,
just
but you
don't
can
want them
also
to
be on
talk
your
about
way.
me. I didn't say physical. I just don't want them to
So-
send any more letters about my family.
We also have your request for an order against Loretta Mollenbry under case number 24-189. I see that she was not served in any way. And have you shown, is there anything you can show that shows that you gave her service or notice of today's date?
I gave it to the sheriff when I left. The sheriff, they know the sheriff didn't serve him. I gave him this stuff.
When did you give them the stuff?
I gave the sheriff when I got the temporary protection.
Okay, so the day that you were before the court, June 6th.
Yeah, I gave it to the sheriff's office, and the sheriff office said they're delivering them. I don't know anything past that. I
All
do
right,
know
so when
Joan
did
and
you last
Avery.
talk to the sheriff about that service?
I talked to a sheriff yesterday,
Mhm.
and he said he was on his way yesterday to go give her the paperwork.
Okay. All right.
And he said that they tried throughout the week, but they typically have a Monday through Friday person, but they're doing it on Sunday. They typically don't do it because he couldn't get involved in contact with them previously.
Okay. All right. So as to the Avnerys, that's 24-190 that you've asked for an order against them. And I see that this court has issued an order as recently as May 13th against the Avnerys, protecting them against you. And here we are 3 weeks, not even 3 weeks after that, June 6th, you filed for an order against them.
Yes, this one I do have a lot more information on.
Well, first off, I
Sorry.
don't see that they were given any notice at today's hearing.
All right, a little backstory on this guy. I probably should have started with the backstory. I'm pretty sure I covered this guy's first case. I don't remember. I know Law Talk with Mike did. I held it for a while. I think I played it. Maybe not. But this guy is the guy that was accused of mooning his neighbors. They live right next to each other. They share an easement. And, you know, there's been harassment back and forth between this guy and the lady who just got off the call. Now he's looking for a protection order from multiple people on this hearing. Again, 150 pages worth of evidence he sent to court. And the judge isn't having any of it. But so he's trying to get a PPO against his neighbors. His neighbors were trying to get a PPO against him. I believe everything's been thrown out. The judge on the first case, she's like, guys, just get along, ignore each other. And this guy's mad because they're sending him letters. They're sending him letters. There's no PPO, and they're sending him letters, and he's calling this harassment. And again, I said it already. You're sending letters, man. Oh, they're sending letters. I check my mail twice a month. Twice a month. I am paperless on all my bills. So if you're physically mailing me something, it's not that important. It's not that important or something I can't wait 2 weeks to see it. And when I check my mailbox, I usually have 3 or 4 things in there. Most of it's junk. This guy is using letters as harassment. It's like, dude, just throw them away. You don't have to open them. You don't have to open your mail. You don't. If you see an address and it's your next door neighbor, throw it away. I mean, Tupac. Let's see. I miss pinball machines. Yeah, I do remember that. I miss pinball machines too. They're still around. You just got to find a cool arcade to play pinball. But today's pinball machines they're not the same. It's not the same thing. You know, remember when you would try to tilt it and the whole thing would go off? Yeah. I know. I'm that kind of guy. But Tupac, thank you so much. Very generous super chat. Also, Terry B, thank you so much for the 4 months. I appreciate it. Thank you so much, Terry. Okay. All All right, let's keep going.
How did you do that?
I do know for sure that they had got the paperwork yesterday when the sheriff went by and gave it to them because
Okay,
they were
what
home all day.
evidence, what I need is something from the sheriff that says in fact that they did that.
And
I don't have that filed with the court.
Then I don't know, sir. Sorry, I'm very nervous. Let me say that, Your Honor. I know they got the notice on their door. I
Okay,
don't
well,
know.
I need something
anything
more
other-
than
That's all I
that.
have. That's all information. I didn't.
Okay,
I had the sheriff deliver them. I thought the sheriffs were delivering them. That was that, you know. And
Right.
I didn't know I had to do anything else other than and I just come to court. I'm just trying to get these letters to stop.
okay.
I
Let me
have a
figure
daughter
out,
due
I
in a
just see
month.
someone coming in his iPhone. Let me find out who that is. So someone on Zoom is coming in his iPhone. Who is that?
My name's Trace.
And you're here for a hearing?
Yes, ma'am. I think this is the right courtroom.
So what do you think you're here for?
I got a ticket for driving with suspended license.
Okay, you're in the wrong courtroom. And so you need to be either in courtroom, well, I don't know. Look at your notice and it'll tell you what courtroom you need to be in, but you're in the wrong place.
Um,
All right. Do you have a case number on there? Are you able to look at the case number?
Yeah.
What-
His name, I can look it up.
Yeah. You got a full name for me?
I'm Trace, Trace, Lynn, Lynn, Dorst, Dorst.
So Dorst is your last name, Dorst? Okay.
Yes.
And let's see. All right, courtroom 2, that's where you
Two.
need to go to.
That's not the one I signed into? Sorry.
Nope, send into 3.
I'm sorry.
That's all right.
Thank you.
All right. So going back to you, Mr. Brown, in case number 24190, your request against the Abneries for an order. So Mr. Brown, I'm going to dismiss this action. There's no order issued on your behalf to begin with. We simply set this for a hearing. But the court already issued an order protecting the Abneries.
Allie, I've talked to him a few times this week. Almost every day. And I've asked him a couple times what day he's free to come on. And he keeps responding with is he's gonna check with his wife and let me know what night he's free. I don't want to push him. He said he would be on this week. I know it's Friday. I'm kind of terrified he's gonna say he's available tomorrow, but I don't know. That's my update, Allie. He said he'd be on, and I trust that he's gonna be on soon, but I don't want to push him. So I'm not just going to keep asking him over and over again. He's busy, right? But yeah, that's my update, Allie. Oh, also got another super sticker. Tina, thank you so much for the super sticker. I appreciate it. Thank you so much, Tina.
Against you.
Your Honor,
Stop. I'm talking.
I'm sorry.
May 13th, and that's in effect until May 13th of 2025. And in your petition, there's nothing in there since that May 13th hearing other than name calling, which is not unlawful harassment. So
What about the
I
letters?
find that your filing for an order against the Abneries, frankly, is vindictive and there is no basis. So I will not grant this
I haven't been able to
request
talk my side. I have the letters I
because there is
sent.
no.
There is
There's
the
nothing
letters.
for
If
the
you look at
court
the
to
image
do,
right
and I
there,
find
if you
it's
look at the image
vindictive
right there, with the guy with his pants
filing
pulled down,
with no
you put a
further
letter in my
information.
mailbox saying, "Stay with me, your neighbors."
So, Mr.
With it,
Brown,
there is more than
I know you
proof.
disagree.
No, I
but
just want to speak my side. I haven't
We've
been able to
already
say my
had that
side.
hearing on the Avery matter on 190 back on May 13th, and within 3 weeks, you're filing for an order against them.
Because the letters they sent.
without
Look at the
any
letters.
information
If you,
that supports this.
I've
And the
been-
letter that's been sent is not sufficient information for unlawful harassment. Even if I were to believe that that's what this is, I find that your filing against them
I
is
just want these
vindictive.
letters.
So we'll
It's not
move back,
vindictive.
we'll move back to the case that you filed for an order against
Who
Mullenbry.
is still logged in? She has no reason to still be logged in.
Yes, she is. It's a public hearing. Anybody can watch,
She's
anybody
doing
can
this
be
so
in
she can
court.
do more things on the letters.
So,
I guarantee you
case
there's
number
things on the next
24,
letters can be
case number
involved in this hearing.
24-189, your request
Denied.
against the Mullenbry, Ms. Loretta Mullenbry, not served. We're gonna strike the hearing. You can always refile if you feel the need, but you haven't shown any service of notice of this hearing. There hasn't been an order issue.
I haven't been able to say anything.
They're not
I've said two
here.
words.
They're not here and you haven't shown
With many of these
service.
cases.
And
Miss,
so
I haven't said nothing.
We're
I
striking
have,
this
I
hearing
have so much
and
information
dismissing
here.
this action.
I have information regarding to her and the person who stole my animals. I have
And
150
we've heard all of
pages.
that going back to May and
Your Honor,
April.
you did
So,
not hear any of this.
This court did and made
No,
decisions.
it did not.
I'm
take
not
my
arguing
court.
with
It
you
didn't
anymore,
take-
Mr. Brown.
I didn't present my
If
court
you
on the
feel the need to
13th.
file
I'm not
petitions, then
arguing.
you
I'm just
need to
telling you what
provide
happened.
evidence.
I never went to court on the 13th.
These are
They-
dismissed. The hearings are stricken. Cases are closed. Time to go. Time for you to go.
Time to go, buddy. Okay, bye. Pack up your 12 phones that you brought.
Right?
Time for you to go.
I'm
Okay, bye.
getting harassed by these
Follow the
people.
orders that have been issued
Your
against you.
Honor, I should be able to present my
Time for
case.
you to go.
I should be able to present my
Time
case.
for you
I
to
have
go,
not been able to
Mr.
present my
Brown.
case at all,
Go.
And this is not okay,
Leave the court.
okay? I've been getting harassed. They've left
Leave
bullets
the
in my
court,
mailbox.
Mr. Brown.
They put
Leave
a-
the court
they sent a
now.
gun man to my house. and I don't
Leave
think
the
there's
court
anybody-
now, Mr. Brown. I'm gonna tell security to make sure he leaves. You and I don't know. All right. Sorry. Difficult.
Woo. Call security and make sure he leaves. Just saying. You don't hear a judge say that often. Chris Barton, good to see you. Good to see you, Chris. Hope you're having a good night. Muse, thank you so much for the 5 months. Hope your emergency was cleared up. Okay. Yeah, it actually was a Heather emergency. For those of you that weren't here last night at the beginning of the stream, Heather got into a car accident. She's okay. She's in the chat. She's here. But she was in a car accident on her way home from work. So I called off the stream to hang out with her for the evening. So everything's good. Her car's not good. She is good. Or yeah. So Muse, thank you so much for the 5 months and thank you for asking. Nick, thank you so much for the $5 super chat. The guy thinks he's spitting poetry in a coffee house instead of being in court. He does. That guy's just weird. The guy's weird. You know, I said this before. You know, you have elderly neighbors who you think are harassing you, and they might be. I don't know why they're sending them letters. Probably because they don't want to talk to him. But they're sending them letters. He provided them as proof. So I'm not going to say he's lying about them sending them letters. But if you don't want to read them, throw them away. You're a grown man. They're, from the look of them, elderly. You know, maybe they're as old as he is, and you know they just had a rough life. I don't know, but ignore them. Ignore them. It's, you know how easy it is to ignore a neighbor. I have a guy that lives right across the hall from me, and I've never said a word to him, and I've been here for a year and a half. Ooh. All right, Nick, thank you so much for the super chat. And Joey Bag of Donuts. I love the name, man. I love the name. Thank you so much for becoming a member. Thank you so much for becoming a member. Legal Fiction, Heather's new car fund. I appreciate the super chat, Legal Fiction. You're awesome. Hopefully, her new car fund will come from the insurance company and not from us. But we'll see. We'll see. But thank you so much, buddy. I appreciate it. All right. The next two guys we have are soft sits. Yeah, we're gonna check out these soft sits, guys. And this is this guy's second appearance. His second appearance. For those of you that don't remember the first one, this is the guy who claims his file is sealed by, I don't remember what he said, the FBI, the CIA. He's on like double secret probation where no one can know who he is. This dude is not only a sovereign citizen, but he is not all there in the head. I guess, you know, that might mean the same thing. But anyways, let's go.
Hello? I'm on mute. Can you hear me?
Yes.
Okay, are they
Joe, what are you
dismissing
ready
everything, or do I still have?
We're ready on
some,
Mr. Bowles,
review
Your Honor, and
cases
it's going to be a
open?
misdemeanor
1 second,
plea.
sir. Mr. Evans, just 1 second. We're in the middle of something. The evaluator did opine that he should be evaluated.
I am so good at editing. I am so good at editing. So good. It's my number one thing I'm amazing at, editing.
The review cases are.
Just 1 second, sir. Mr. Evans, just 1 second. We're in the middle of something. The evaluator did opine that he should be evaluated by DCR prior to release. And the court is adopting that, indicating that should be held until no later than noon on the 25th for that purpose. And that is, he was
So we got RB.
unable to proceed under both prongs.
The end of 2007.
Mr. Mercer, does he have a history of one or more violent acts?
I don't know that we have out-of-state history on him.
Okay. And all I see here is the.
Was I found competent or incompetent?
No, Mr. Evidence, we're not, this is talking about someone else. Now we're about to address your hearing.
This is standard.
Okay. And this is City versus Sylvester Evans.
Hey, Sanders, it's showing the blue line.
082.
Data, thank you so much for the PayPal. I don't want to say your last name. I don't know what your YouTube name is, so I'm not going to say your last name. But Theta, thank you so much for the PayPal. I appreciate it. That was awesome.
2019.
Everybody can come out.
65525 3A0549215 4A0231898 4A04725552 and 3A0312319. Have the parties had an opportunity to review the evaluation?
Yes.
Yes.
Did either party take exception to the court adopting?
I have an objection.
All right, so we're.
Object to the court adopting the evaluation?
What's the status of the evaluation? Was it competent or incompetent?
I'm not able to proceed.
So I mean, they found me incompetent?
Yes.
Okay, could I see the paperwork on that so I can review it and have that challenged?
So just to be clear, if you're incompetent, everything gets dismissed. If you're competent, then everything proceeds.
So that's what I'm asking. Did the doctor find me competent or incompetent?
Incompetent.
Okay, under what circumstances? What was his reasoning?
Delusional thinking.
And what proof did he have on that?
I mean, the interview that he did with you.
Okay, and being that you said everything is dismissed due to delusional thinking by law, from what I read at the law library.
Sparkle, was that you? I mispronounced it? Did I really? That's okay. All right, well, I mispronounced it. You're going to have to tell me later, either tonight or sometime this weekend in Discord, how to pronounce it. But yeah, your full name comes across when you are on PayPal, unless you change it. But thank you so much, Sparkle Prudes, for that. I appreciate it.
It said being delusional in itself is not reason in itself to be declared incompetent.
That you are unable to assist in your own defense because of it. So there are two prongs, there are two ways that you can find someone unable to proceed, that they don't understand the nature of the proceedings, which you clearly do, and the evaluator said that. But that you were unable to assist in your own defense due to the delusional thinking.
Well, that's being with the letter that I sent to you, that would directly refute that, correct?
No, that supports that.
what the letter I sent to you, it had motions that I wanted filed and whatnot that would prove that I'm able to assist in my defense, correct?
No, it was, you wouldn't give me any.
All right, I didn't want to pause it again this quickly. I'm pausing it a lot tonight. I'm sorry, everybody. But Fletcher's leaving. Thank you so much for the super chat, Fletcher. I hope you have an enjoyable night playing music for Drunk Tourists. That's actually kind of cool. So you play music somewhere, which is awesome. Playing for Drunk Tourists, that part's not so awesome. But playing music, I'm sure you enjoy it. So enjoy the rest of your night. I'll get to the rest of the super chats between the clip.
Information. You gave me half information about things, refused to give the further information when I asked in court.
I did declare that the information regarding the evidence, that was a matter of secret state privilege. And then I also declared that the motions that I want to file, I didn't have access to the law library to get the proper documentations.
I am adopting the evaluation over your objection, and finding that you are unable to proceed in these matters. So the pretrial cases are dismissed. All of the reviews are closed pending a further finding of able to proceed. The evaluator did not opine that you should be evaluated by DCR prior to release, so you're just released today. You can appeal this. You're welcome to appeal this finding, this ruling, and you could come to the court and the clerks can tell you how to do that, what paperwork to file.
All right, so I'll be released from jail today.
Correct.
And also, can I get the paperwork of the evaluation from the doctor?
You represent yourself, so I think you kind of have a right to it.
Yeah, how do I get that paperwork?
Mr. Ainati, are we able to print that out for him?
You can print it off and give it to the officers to give to them.
Okay, we'll get that to you today.
Okay.
All right, thank you, Mr. Evans.
And also, I want to put on record that I want to file a notice to appeal to the Supreme Court of the state of Washington.
That's appeals from courts of limited jurisdiction go to King County Superior Court.
I understand that, but I want to bypass the Superior Courts and go directly to the Supreme Court due to the circumstances and the nature of the judgment.
Okay, you can try to do that.
I want it on record noted. If you
you
have
to actually file it. That means nothing. You have to actually file the documentation. You have to file notice.
That's impossible to do from in here. You're saying when I get out, I have to file it?
Yo, you're getting released. You are found incompetent. They're releasing you. They're not going forward with the charges. Just shut up. I am sorry. I don't usually tell people to shut up. Dude, stop talking. Hold on. This is the perfect time for this clip. This is the perfect time. I didn't have it loaded. It's going to take me a second. Here we go.
Don't answer, sir, please. Every time you open your pie hole, you get it worse trouble. So stay the course, will you?
That's correct. You'll have 30 days to file it.
Okay.
Okay. You should know, though, that you are still trespassed from the airport. Nothing in what I've done today affects that. That is the airport's trespass notice. It is still fully valid. You will be rearrested. Okay?
So even if I'm there on personal travel, I'll be rearrested.
You have to comply with their rules and restrictions. I'm not going to give you legal advice as to what that constitutes, because you need to look at your trespass notice. But
yeah, I was there this time on legal business.
We're done. We're done with this case. This case is dismissed. So you don't owe me any explanations. I'm just telling you that the trespass order from the airport is still out there. Okay? I'm just letting you know.
Okay, so I can still be arrested under false premises, because they also said I confessed in this case, which was not true.
I'm just telling you that the trespass order is still there. That's all I'm telling you. Okay, thank you, sir.
Okay. Also, what I want to.
All right, can we all pay attention to the fact that he has an earbud in? That's how he's listening to the court. I don't know if everyone's like this, but I won't share my earbuds with people. I think that's gross. And they have an earbud that they give the prisoners, I'm guessing. Why else would he have it in his ear? He's in jail right now. So, yeah, they're just passing around an earbud back and forth. Maybe it's not as gross as I think it is. I think it's gross.
Fire Mr. Iannetti as
He
well.
doesn't represent you. We've already gone through that. He doesn't represent you. You can't.
Okay, well, is he gonna give me the paperwork that I need for these proceedings?
Score will.
Okay, and the evaluation as well from the doctor?
Yes, I believe we'll be printing that out. Mr. Inati said he would print that out for you.
Okay.
All right, thank you, sir.
Oh, what is going on with the review cases? I guess I haven't
They're
heard
all
that part.
closed. They're all closed, pending a further finding of able to proceed. If made within-
Closed. What does that mean?
It means there are no affirmative conditions or no conditions can be imposed because there's a finding of unable to proceed.
So they can be reopened later.
They can.
So I can have a warrant placed and I don't even know it once again.
Well, no, you would have to get notice of a hearing.
Like this time I didn't get notice of the review hearing and they placed the warrant out for failure to appear. I didn't even know I had a hearing on the review charges.
Okay, this is why it's very important to keep your address updated.
My address is very I don't know, for lack of a better word, I do a lot of moving around, so I don't have a steady address that I can always.
AKA, he doesn't have he's homeless. He might not be homeless. He might couch surf, but yeah, that's what that. I mean, this guy. Stop talking about your case, man. He's not talking about his case now. He's just talking too much. It's over. Just go home. Just go. The judge is like, we're releasing you from jail. Why is this so complicated? But the prosecutor is even like, this doesn't make sense. Everyone's confused.
Get mail at the moment. So that's how we got in this position the first time.
Well, so that sounds like, I mean, if you're not going to let us know how to get in touch with you, then you can't complain when you don't get notice.
I can give you an email. Would you be able to contact me by email?
And I think we have that listed.
But they never gave me a notice of any hearing via email.
Okay. We will make a note, email only.
And I'm still confused as well. The case is open or closed?
Closed. He's unable to proceed.
And I'm confused by that. So the conditions were imposed. There's an allegation that he violated him. He's not found competent. We can't move forward in those violations, but it doesn't invalidate the conditions that were set because those were done at a time that he was competent. Like, is the court still taking jurisdiction? Like, I'm still struggling with that.
I can't impose conditions.
You just got blocked from what? My channel? I see your message. Was it an accident? I see you, Chris. I see you. I hope you weren't blocked or timed out. I didn't see you say anything bad.
Conditions were already imposed, though.
I know, and they're stayed. Everything is stayed.
Sure. But so the case is open but stayed, or is it
I guess
closed?
that's maybe a better way to characterize it, but it's for all intents and purposes closed, effectively, pending a further finding of able to proceed.
And also, would I be able to subpoena any grand jury proceedings that may have taken place as well?
There are no grand juries in courts of limited jurisdiction, and I don't believe there are in Washington at all, other than federal.
Okay. And so you said, yeah, I'll get a copy of the evaluation, and you say I got 30 days to start filing motions to try to get everything reversed, right?
At this point, your only avenue is appeal.
Correct.
Okay. All right. Thank you, sir.
So I think the city is objecting to them being closed in any way.
So they're not closed. They're just, I mean, I thought we talked about this.
I know, but when we're using words like closed, is there going to be a CL for
No.
closed disposition?
No.
Just let the guy go home. I understand what the prosecutor's doing. He's trying to clarify the record on his side because this guy's competent. He's just an idiot. So it's like these charges are probably going to come back, especially if he goes back to the airport, because that's where he was picked up at. So if you say it's closed and he comes back, we can't charge him as a habitual. But if we just put in different wording, we can charge him as a habitual. So that's what he's trying to clarify, and I understand. But this goes on way too long, and I've got PayPal's. You guys are awesome, but I want to let this video play out. So I'm going to let the video play out, then I'll shout out everybody.
Because that's what's going to be in the docket is they're closed. And so in a year or two, if this comes up again, it's going to be very difficult to figure out what exactly happened today. If we're
Well, in
using
2 years, it's too late. Jurisdictions run.
Sure, there's some situations where that wouldn't be the case, but so the cases are open is all I'm trying to understand.
Yes, they are not closed. They're just.
Okay.
Okay, so would you be able to clarify that for me, Miss Your Honor, in layman terms, so I can get an understanding, because you said it's not closed, but it's open closed, which is kind of difficult for me to understand.
I am. You guys are right. I should use more careful language. The cases are open. They are stayed, which means frozen, essentially, unless there's a further finding by a doctor that you are able to proceed.
Would that be able to be done in the appellate courts or the state Supreme Court, or overturning his findings, or what? How do you get the proceedings to be found? How do you get that overwritten, basically, what the doctor prescribed or diagnosed?
So, and this is interesting. It's a situation I haven't come across where there's an individual wanting to contest the finding.
Yeah, based on, I don't have the law library's information in front of me, but based on the information I got from the law library, the defendant cannot be declared incompetent by being delusional in itself.
And
that's
I
law.
explained to you what the evaluator opined, that your delusion is impeding your ability to assist in your own defense. That's what the evaluator. Am I characterizing that correctly, Mr. Mercer, Mr. Ainati? That's what it sounded like to me.
In what way, though? How is it impeding?
You're asserting defenses that don't exist.
Such as?
The stuff about the case in Louisiana.
I asserted evidence that has a seal on it. So the only way he can find out that it doesn't, what I'm saying is not true, is to get the seal broken on the evidence, which is under state secret privilege. And the only way you can get that broken is by orders of the president or Chief Justice Roberts of the United States Supreme Court.
So when you get all your ducks in a row to get that happening so that the court can see it, it sounds very far-fetched. I've never heard of anything similar happening on a state case that the U.S. Supreme Court would involve themselves, much less that any one justice would have authority to unseal something. I'm adopting this finding. You can appeal.
Is everything that we spoke about today on the record? Would I be able to get recordings of all the subpoena recordings of all the hearings, including what we're talking about today?
They are all online, available for you to listen to anytime you want.
Okay, and they all can be subpoenaed by the state Supreme Court and whatnot to be overturned or sealed. Also,
they are not going to do any investigation on your behalf. If you're appealing, you have to do all the investigation.
Right. No, I don't need them to do the investigation. Everything's pretty much said and done. The only thing is the assumption that you guys don't believe the evidence is under state secret privilege, and I am who I'm telling you I am. So you're believing I'm delusional. Am I correct?
That's correct.
Right. So y'all making assumptions that's not true, that I have to go through the process and get everything removed to the federal courts to prove that it's true, which is going to be under seal at that moment. But I give.
Hey, listen, guy. Let's just pretend you're right. You're exactly this super secret agent that you're saying you are. The court found you incompetent. Maybe that is your higher power. Your boss's saying, you know, we got to let this guy out. This guy's an asset to us. Let's just pretend he's crazy so we can get him out of jail. It worked. Stop talking. You're getting out of jail, man. Why are you fighting this? If you were this super secret agent you're talking about, you probably would have picked up on that's exactly what happened. You also wouldn't be talking about it. Let's be fair.
The state Supreme Court a chance to make the adjustments and override.
Okay, thank you, Mr. Evans. You'll be released today and you can get working on all that. All right, thank you, sir.
All right, so we're done here?
We're done here.
Appreciate it.
I didn't know I cut it off right there. There's still a little bit of back and forth between the prosecutor and the judge explaining like how exactly do I put this in the file that you're just letting them go or whatever. Anyways, let me catch up on some super chats real quick. Dwight, thank you so much for the super chat. Heather's new car fund deductible. Thank you so much. I appreciate it, Dwight. Yeah. That's going to be needed. But yeah, thank you. MB, you are the self-deprecate. You are the best at self-deprecation. Thank you. Was that? I think you said that when I was talking about how awesome I am at editing. But thank you, MB. I appreciate it. Crazy. Was it? No, it's not. Yeah, it is great. Crazy writer. I was right. Love it when they think they're winning and they are actually not. No, that guy won. He won. They're letting him go. He's gonna think of that as a sob sit win. But yeah, thank you so much, Crazy. I appreciate it. And Nick, guys, missing out on the time to argue more. Yeah, he really is. Thank you so much, Nick. I appreciate it. Also, let me hit up these PayPals real quick. I'm whatever on YouTube. Is there someone in the chat named whatever? Or are you just saying that? Yeah, I don't know. So I'll just say, thank you, whatever. You do great work. Your next level with judge interviews, much appreciated. Thank you so much, Lisa. I appreciate it. There was one more. Nice bottle of wine for you and Heather. And this is Sly. I thought so. When I saw the name, I'm like, I'm not going to say that name. Thank you, Sly. I appreciate it. That's very generous. And there was a Cash App too. Liz, thank you so much for the Cash App. I appreciate it. Thank you so much. You guys are awesome tonight. You guys are awesome. Fridays are awesome. All right. Okay. All right. Let's keep going. We have another soft sit. There's another one right now. Right now, there's another one. Grab your popcorn and your Coca-Cola and relax. Here's the soft sit. This one's a little gross. I should warn you.
Len, Derek,
this one's a little
Tyler,
gross.
Stringer. Mr. Engott, do you wish to place an appearance on the record?
Judge John Engott, I'm here as appointed counsel for Mr. Stringer regarding this arraignment. However, Mr. Stringer does not acknowledge or consent to this hearing. Is that correct, Mr. Stringer?
I do not identify. I identify as the beneficiary that is here to protect Derek Stringer.
Very well, Mr. Stringer. The court is going to read the charge into the record since the formal reading is not waived. Mr. Stringer, it is charged by the people of the state of Michigan that in this city of Royal Oak, county of Oakland, and state of Michigan.
All right, I'm so sorry. Whatever. The way that was read, that was typed, it was just like this is whatever in chat, and I didn't know if that there was someone in chat named whatever or yeah. But I appreciate the PayPal. Thank you so much. I'm gonna stop talking. I'm gonna stop talking.
On or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area, contrary to the statute so made and provided at Michigan Compile Law 750.335A, subparent 2, subparent B. The court advises you that this is referred to as a Tier 1 offense under the Sex Offender Registry Act. If the victim is a minor, it is a Tier 2 offense. If you have a prior conviction for a Tier 1 offense, it is a Tier 3 offense. If you have a prior conviction for a Tier 2 offense. This is a high misdemeanor, punishable by up to 2 years in the state prison and up to $2,000. Also, a mandatory collection of DNA identifying profiling samples. There is a count 2 misdemeanor in that on the same date, you did knowingly make an open or indecent exposure of your person contrary to the statute so made and provided at Michigan Compile Law 750.335A, subparent 2, subparent A, commonly known as indecent exposure. At this time, the court enters not guilty pleas on both of these matters so that Mr. Stringer's presumption of innocence under the constitutions of Michigan and the United States are preserved.
Sir, excuse me, sir. You have not talked to my beneficiary yet. You have not talked to the person who owns the estate yet.
Mr. Angot, the court is making a notation of court-appointed counsel to run through the IDSO office, and that new counsel, as appointed by Mr. Mena, can make whatever judgments they wish to make and make any motions they wish to make at Mr. Stringer's first probable cause conference. Mr. Stringer, this matter is now being set for a probable cause conference. That will be on a new date. The law entitles you to what they refer to as a preliminary examination within 21 days of this arraignment today. If probable cause is either found or waived at that preliminary examination, the matter will be bound over to the Oakland County Circuit Court for further arraignment, trial, and proceedings. The court must now set bond in this manner. That's not intended to prejudge or punish you. You are presumed innocent, Mr. Stringer. However, the court must set bond in order to ensure your reappearance to court and afford any necessary protection for the public. In that regard, the court would first hear from Detective Keith Baringa of the Royal Police Department. Then the court would hear from your attorney, Mr. Stringer. Detective Baringa, please proceed.
Thank you. Cash bond in this matter and GPS tether to ensure his appearance at court. He currently has 2 warrants out of the state of Texas for assault and also in assault with injury to family violence out of Texas. He also has a lengthy criminal history out of Texas, going from as recent of these warrants, which were entered last year, back to around 2015, receiving charges for evading arrest and detention, unlawful possession of a firearm by a felon, assault, family, house member impeding breath or circulation, several other assault charges, a weapons charge, and then also like falsifying information or government documents. I'm not sure if that's just like a generic false ID case or not, but multiple felons out of Texas. I'm not sure how long he's been in Michigan. He has no current cases out of Michigan that I'm aware of. His criminal history, he has assaults from 2019 out of Markwood Woods, which looks like it was deferred as assaulting a public officer or obstructing, where he got served 9 days ago.
All right. So this guy is not good. Not a good guy. You guys are cracking me up in the chat, by the way. I'm laughing, but I don't want to bring. You guys are making hilarious jokes. I just can't bring them up on the screen. But keep them coming. Keep them coming. I'm laughing my ass off over here.
And that is it out of Michigan.
Anything further?
So I would also ask that he not be allowed to return to any public or private pools in the city of Royal or parks, grass areas adjacent to it.
Thank you very much. Mr. Angot.
Judge, as noted by the court, the presumption of innocence is absolute at this point. And so we must start from there. Mr. Stringer, or the person purporting to represent Mr. Stringer, is a business owner. Judge, despite the fact of these charges and what was listed by the detective, I believe that with the GPS tether, that certainly would give this court, pretrial services, and any other entity overseeing Mr. Stringer during the pendency of this matter, notice of where he would be within 3 feet, is my understanding, with that tether. I don't think a cash bond is necessary. I would ask the court to give him a personal bond with the GPS tether.
Thank you very much. The following conditions will apply to Mr. Stringer's release. Mr. Stringer will appear for all his future dates as directed. He will abide any valid order or judgment entered in this case. Mr. Stringer, you will not leave the state of Michigan without permission of the court. Please don't commit any crimes while you're on release status. You will notify the court in writing of any change of address, telephone, or email. Mr. Stringer will be making reports to pretrial services and they will supervise his release. There will be no use of alcohol, marijuana, or any other controlled substance without a valid prescription from a treating physician, and Mr. Stringer will abide a substance abuse testing and monitoring program. No purchase or possession of a firearm or other deadly weapon. Mr. Stringer shall not harass, intimidate, beat, wound, or threaten Linda Marino and Chad Stransky, nor will he cause through himself or through any third party to have direct or indirect contact with said individuals. Mr. Stringer will not enter the cities of Royal Oak.
All right, this one's almost finished, but I want to point this out real quick. Notice what's behind him. The toilet water fountain combination. When I was visiting Judge Slavin, when Sly and I were there, well, Donald was there too. So when we were there, Judge Slavin was giving us a tour and he locked us in the holding cell and it had that. And Judge Slavin made the point, like, sometimes I just put people in here to scare them. So when they're, not following court orders, but I don't want to throw them in jail, I'll throw them back here for a minute and just sitting here staring at a toilet that you also drink water out of. That works. That works. It's yeah, that's what you have. That's what you have. So his water fountain and toilet in the same contraption, that would scare me.
Or Berkeley, except for court, work, or medical treatment. No release without a GPS tether with appropriate alerts. For the victims in this case, as well as the location. Which is in fact 2024 Wickham, correct, Detective?
That will work.
Thank you. And at this time, there will be 2 ETGs per week for control alcohol consumption and 3 controlled substance tests a month. Given everything that's before the court at this time, the court will set bond in the amount of $50,000. Cash or surety, no 10% allowed at this time. If Mr. Stringer wishes to bring various motions before the examining judge, and that could include a motion to modify his bond, that is his right and his privilege, but at this time, that is the bond as set by this court. Mr. Stringer, that concludes your arraignment, sir.
Sir, so I can't get out on a personal bond?
That's correct, Mr. Stringer. You cannot get out on a personal bond. 50,000 cash or surety with the appropriate conditions that were already listed by the court. That completes your arraignment, sir.
Sir, so what is going on with what is going on? Right?
I'm sorry, sir?
I'm being charged. I'm being charged for entity that is.
Can you please move up so the court could hear you?
I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
it just happened right before your eyes. The court has jurisdiction over you, sir. Venue and jurisdiction have been established by sworn testimony. That completes your arraignment. Good luck to you.
We're about to go to war.
I love it. How do you charge a dead entity? It happened right before your eyes just now. I just did it. If you want to call yourself whatever you want to call yourself, I don't care. You just got charged. Chris Barton, thank you so much for the very generous PayPal. I appreciate it. And yeah, no, thank you for being my friend. That is more important. I am happy that you're here, Chris Barton. I am very happy that you're here. And thank you so much for the very generous PayPal. Okay, I'm all caught up. All right. We're moving on to the last one. The last one's a little. We're already over an hour. Man, time flies when you're having fun, I guess. Okay, last clip. Let's go.
Step right
Step a little closer. Thank you. Okay, so what I have is a fresh one, a fail to appear, and a failure to pay. So that's the order we'll go through them. All right, first.
All right, I'm not gonna lie to you. When this guy walked up and Judge Buchanan, I like Judge Buchanan a lot. She seems really sweet, but she will drop the hammer down on you. But she just seems super sweet, and all you want to do is you just want to confess all your sins to her. When she starts, asking you questions, like I'm just like, I did it, I'm guilty, because she just seems like that. She radiates kindness, but she's the judge. But he walks up. We have a fresh one. We've got a fresh one. All right, let's go.
We'll go on the record in state of Michigan versus Michael Amory. Appearance, please.
Thank you, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Michael Amory for the purpose of arraignment. Mr. Amory is making application for court-appointed counsel on the new or fresh file, and I would ask that a not guilty plea be entered on that on his behalf in that file. I will also note when we get there, Mr. Amory is already represented by the Public Defender's Office, and specifically Attorney Jacob Sartz in the failure to appear file.
Okay, thank you. And you, sir, are you Michael Amory?
Yes, Your Honor.
Okay. Mr. Amory, what I have here is a felony complaint. This alleges that on or about June 18, 2024 at South Pennsylvania and Kendon Drive in the city of Lansing, Ingham County, Michigan. Count 1 says receiving and concealing a motor vehicle that you did buy, receive, possess, conceal, or aid in the concealment of a 2009 Nissan Sentra, a stolen motor vehicle, knowing or having reason to know or to believe the motor vehicle was stolen, embezzled, or converted. This is a felony punishable by up to 5 years and or $10,000 or 3 times the value of the motor vehicle, whichever is greater. There's a habitual offender third offense notice that says take notice defendant was twice previously convicted of a felony or an attempt to commit a felony. In the on or about February 20th, 2008, he was convicted of embezzlement 1,000 to 20,000 in 30th Circuit Court. And on or about December 30, 2015, he was convicted of delivery manufacturer less than 50 grams of controlled substance in 30th Circuit Court of Ingham County. Therefore, the penalty is twice the maximum penalty on the primary offense or a lesser term. The maximum penalty cannot be less than the maximum term for a first conviction. So what that means is this RNC motor vehicle charge goes from a 5-year to a 10-year. Do you understand the charge and the possible penalty?
Yes, Your Honor.
You have the right to have an attorney in this matter. If you cannot afford one, we'll see if the public defender will represent you. You have the right to have a trial that could be by jury. You have the right to remain silent. Anything you say orally or in writing will be used against you in court. You have the right to have an attorney present with you during any questioning by law enforcement. You understand these rights so far, sir?
Yes, Your Honor.
All right, Mr. Palmer said you'd like a public defender, so I wrote that down that you requested a public defender. Since there's a felony charge, you have the right to have a preliminary examination. That's a hearing where the government must bring some evidence to demonstrate probable cause to believe the felony occurred and probable cause to believe that you're the person who committed the felony. You're going to have a probable cause conference before your preliminary exam, a day where you, your lawyer, the prosecutor determine that you have all the evidence and information you need to be ready for probable cause conference. Yours is scheduled for June 27 at 9:30 with Judge Ward. And then you'll have your preliminary exam July 5th at 8:45 also with Judge Ward. That first hearing may be by video conference like we're doing now. But if you can't video conference, don't want a video conference, your phone is broken, you should come in person. And the second date, the preliminary exam is absolutely in person. You have no choice but to come in person as evidence, testimony, witnesses may be present at that time. Mr. Amory, I don't think they gave me an address for you. Do you have an address where you can receive mail?
Yes. 1328 Mark Twain Drive, Lansing, Michigan, 48911.
Is there an apartment number or anything I need to put with that?
Yeah, I'm gonna mute it for the next second. I missed that.
1313.
Oops, didn't mean to pause. I meant to hit mute.
This Mark Twain Drive address, do you still?
All right.
I've been as male and I stayed here. I've been a little bit homeless lately, but it's both. My mother's getting the house it's getting remodeled right now. But yes, I've been there since second grade. It's my home since my address, my home since second grade. So yes, it's a good address.
Well, you said it's your mom's address, so I guess that's the question. Is your mom letting you stay with her?
Yes, ma'am. Yes, Your Honor.
Okay. All right. Mr. Palmer, keep in mind, I'm going to arraign him on a failure to appear in a moment. And then just so you know, his Michigan criminal.
Yeah, so some courts will put it on the record. Most don't anymore. They don't want it on YouTube. So I generally will put a little note on my clips when I grab them that, there's an address I need to edit out. I apparently missed this one. Nick, thank you so much. Yeah, I get it, Your Honor, but did you see the scrubs? That's good. That's good. No, this is an outfit because he probably, I don't know what he did to his old clothes. There's a lady that comes in after him. I don't have that clip to share with you guys. It was a pretty straightforward case, but a lady comes in about 10 minutes after his case is over, and she's wearing the exact same thing. So this is something they gave him in jail. Guessing because his clothes were soiled in some way or another.
History looks like 2008, the embezzlement, which I think was in the habitual. 2008, disturbing the peace. 2009, larceny, 200 to 1,000. 2009, driving suspended second. 2011, the same. 2015, the delivery less than 50 grams and a delivery of marijuana charge. Looks like 2 of those were convictions. 2022, convicted of lying to a peace officer in a serious misdemeanor investigation. And then a bunch of 2022 bindovers to circuit that I have no idea what those turned out to be. More of that, more of the same. Apparently they're not giving us the disposition. All right, that's about the gist of it.
Thank you, Connor. I would ask that the court consider, and recognizing that the court still has to arraign Mr. Amory on a failure to appear, I would ask that the court consider a personal recognizance or a low 10% bond. I will note that Mr. Amory, as he has indicated, has strong ties to this community. As he just advised the court, he has been essentially living at the same address on Mark Twain Drive since second grade. So certainly he is longstanding ties to this community. His family is here. He has stable residence here. Additionally, my understanding is that at the time of his arrest, Mr. Amory had just received a call back from Peckham where he has been scheduled for an interview. So he is currently in the process of trying to obtain employment through Peckham. I will also point out that that this case does not involve an assaultive crime or a weapons offense. And of course, as the court is well aware, Mr. Amory has a presumption of innocence in this matter. I would ask that the court consider, as I indicated, a personal recognizance bond or a low 10% bond, also acknowledging again that he has another file to be arraigned.
All right, notice how this guy went from, trying to act cool to the praying / begging stance. We'll see how long that lasts. This is about to get good.
Yeah.
Please.
I guess the other thing I will say, Your Honor, for what it's worth, it's a little bit ambiguous here, but and I know that the failure to appear is on the file, so we're not quite there yet. But it appears that the confusion there, I bring this up now so that the court can take both of these into account. It appears that the confusion there was that Mr. Amory, at the time he allegedly failed to appear for court on the other file, there was some confusion about whether he had been actually provided with the court dates. And the reason I say that is that at the time of his arraignment and probable cause, I believe he was in custody on a child support matter. And then he was, the notes are ambiguous, and I'm not familiar with Mr. Amory, but it appears that he was then released somewhat unexpectedly between the time of the probable cause and the preliminary.
All right, Allie, there was a guy in, I think it was Judge Webster, somewhere in Kansas today. It might have been Judge Ricky, I don't know, who looked like Timothy Chalamet today, and I could not stop laughing. It obviously wasn't him, but every time I looked at him, I was like, I can't look at this guy, because I feel like he had his hair like slicked back. I feel like, you know, when you kind of look like somebody and then you make yourself look like him on purpose, I feel like it was that guy, and he was in jail. Not the best look to have in jail, but I didn't grab the clip. It wasn't that exciting, except for he looked like him a little bit.
Examination. And it's
so that doesn't match the file because the prelim was adjourned twice, and I have a court notice here with the initials of Judge Ward's court officer showing that she handed him personal service of this notice of the preliminary exam that he missed.
Understood.
All right, based on the fact that this is not an assaultive offense, I don't think a high bond is necessary, but based on the fact that Mr. Amory has a history of failure to appear, he has a habitual offender third offense notice, so it's alleged that there's been, I guess, multiple sort of contacts with the system, and at least several of them have been crimes of dishonesty, and one of the last ones was like providing false information in a misdemeanor investigation. I just have concerns about Mr. Amory's cooperation. So in order to ensure his appearance for court at this time, and considering the fact that he's not going to get a PR bond in the other file, bond will be set at 1,010%. And so 1,010%. Conditions: appear for court. I gave you 2 court dates, June 27, July 5. Do not leave the state without permission. Do not commit crimes. Notify the court in writing if you change your address or telephone number. You need to make a report to pretrial services the first business day after you get released. Do not use alcohol, marijuana, or controlled substances. And do not possess or purchase a firearm or ammunition while on bond or any other dangerous weapons. You understand your bond in that case, Mr. Amory?
Yes.
Okay. Now we got to do the fail to appear file next. This file is State of Michigan versus Michael Amory 2400131FY. We still have Mr. Palmer before the court with Mr. Amory. And this is a case, you may remember the complaint, Mr. Amory, is looks like 4 counts of receiving or retaining without a consent a financial transaction device with a habitual offender third offense notice. According to the docket notes that I have, it says March 22nd, you appeared in front of Judge Ward from the jail, and she talked to you about how you didn't have an attorney. April 11, you had an attorney, and he took care of your probable cause conference. April 14, you were brought from the jail in front of Judge Ward, and the prelim was adjourned. And that looks like you were handed a court notice for June 14 by Mr. Harris, the court officer.
No, just look at this dude. He has stopped paying attention. He's like, oh, you guys have my criminal record. I thought I was just here on this case. Oh, no. All right, I'm not going anywhere. He went from praying to begging, and now he's just like, yeah, I'm not going anywhere. Gave up on everything. What? He's just swatting at flies a second ago. No idea what he's doing anymore, but just watch him.
June 14, the complaining witness and the detective were present, and you were not present. So that's how you got this bench warrant. Looks like Judge Ward put on the bench warrant a $10,000 cash surety bond.
How much is it?
10,000 cash surety is what she put on there, but we can talk about that. The court date for your preliminary exam will be rescheduled. I'm gonna estimate that they'll probably put it on for the same time as your other one on July 5th, because that just makes sense that they would consolidate your court dates, and they gives enough time for the prosecutor to be notified and provide subpoenas.
Oh my goodness. Oh my goodness.
All right. So, Mr. Palmer, you said Mr. Amory seems to have said he didn't keep track of his court date. He had a reason he thought he didn't have notice. I say he had notice, but maybe he lost it. I don't know. Anything else?
Your Honor, it's substantially the same bond argument. And to be clear, I'm not even suggesting that it was necessarily Mr. Amory's. It's not my file, and so I'm not familiar with it, obviously. But the concern there was that it appeared that at some point he was in custody, then there was an adjournment, and then it was unclear to me whether he received notice based on the notes in the file. It sounds like Mr. Harries, as the court has indicated, there's a note from Mr. Harries that he provided Mr. Amory with notice. I have no basis to agree or disagree with that allegation. I will simply say that Mr. Amory, based on my interview, Mr. Amory was unaware that he had a court date on the 14th or that he missed it. So I would just ask that the court take that into account. I would also ask that the court, I understand that Judge Ward has identified a bond number. I would ask that the court consider a reduction of that bond number. I recognize that Mr. Amory has a 10% bond on the other file for which he was just arraigned. I would ask that the court consider bringing this bond more in alignment with that.
Okay. I'm going to add a no contact order to this file. So just so the jail's aware, he didn't have a no contact before, but I'm going to add a no contact with the witness. Partially because there is a named specific witness and because I want this in lien. I don't think there was that condition before. Okay, in order to assure appearance at court for Mr. Amory and the fact that he's alleged to have committed a new offense while on bond, bond will be set at 3,010%, subject to the following conditions. The conditions will include appear for all your court dates. You're going to receive a court date. It's probably going to be July 5th. That will be mailed to your address. So appear for your court dates. Do not leave the state without permission. Do not commit any crimes while released. Notify the court in writing if you change your address or telephone number. Do not use alcohol, marijuana, illegal controlled substances. Do not purchase or possess a firearm, ammunition, or a dangerous weapon. Do not engage in any assaultive or threatening behavior. Specifically, do not assault, harass, intimidate, beat, molest, wound, or threaten Keisha Mabel. You are not to cause any contact with her. You're not to have contact. Do not cause a third party to have contact. No contact with her whatsoever. And you're not to be within 2,000 feet of where she lives.
All right. It's that time of the night, guys. It's that time of the night. I can't believe I paused a lot tonight. We're almost at an hour and a half. I was gonna play the turtle video tonight. I was gonna sneak peek the turtle video for everybody. The emotional support turtle from a week ago that I've been telling you I have. You guys want to watch it? It's been a long night though. I usually stop at about an hour to hour 15, and we're almost at an hour and a half. Let me know if you guys want to see the turtle video.
Lives, works, or goes to school. If you violate an order of no contact, you can be arrested without a warrant. Your bond could be revoked. You could be in contempt of court, for which you face up to 93 days in jail and or $7,500 of fine, separate and apart from that which you already face. This order is about you. It's not about her. I don't know how you know her, or if you even do know her. But if she were texting you or calling you, she can do that. You text or call her, you're the one who goes to jail. She does not have authority to give you permission to violate this court order because it's the court's order, not her order. So if she invited you to meet up with her and you went, you'd still be risking jail. Just to be clear, I did order reporting to pretrial services on this file as well. All right. Anything else, Mr. Palmer, before I go to his collections file?
Your Honor, just very briefly,
All right. I'm gonna play a turtle video. I was gonna say I'm just gonna skip to it now. The rest of this video is boring, but you guys have watched it to this point, so I'll let it play out. But yeah, I'll play the turtle video. You guys have your emotional support turtle video.
I apologize for this. Somehow on the first file, the new file, I wrote down that the prelim was July 5th. I did not somehow record the time. Could the court give me that?
Yeah, I think. Is this it?
How much money is it for me to get out of jail?
The time is, the prelim is 8:45.
8:45. Thank you. I have nothing further.
Well, so far, sir, it is 300 on the older file plus 100 on the newer file. So that's 400. We just need to talk about your collections file now, Mr. Amory. This is State of Michigan versus Michael Amory, 1-803-858-OM. Mr. Amory, this is just an old file for which you owed fines and costs. Your, it was like an old income tax file, I guess. And it says you were ordered to make payments. You never did. You've seen the magistrate. She's giving you instructions to come in and set up a payment plan. You never show up. The last time you saw her and were instructed to come in and make a payment plan was in March of 2024, and you just never showed up. Mr. Amory, any reason why you don't at least come in here and set something up with us?
I don't have a job. I've been looking for a job for the longest time. I need a job to set stuff up. I don't have the money. It frustrates me.
Yeah, I hear ya, but you can come in here without any money in your pocket and talk to us about it so that they don't issue these warrants for you, so that they know that you didn't forget about it or you're just ignoring it. When you don't show up, the court, including all the clerks and myself, think you're ignoring it, and then you get a warrant. You don't need these warrants for failure to pay.
I got so much stuff on my mind, man. I'm not thinking about no collections, man. I can't even get out of jail again. Nah, I'm just about to go sit down, man.
All right, well, I'm just gonna put in the file, let's put in the file every single time, which is you need to come and report to the court and set up a payment plan when you get out of jail. You don't have to have $1 in your pocket to come in and talk to us about the file, but continuing to ignore it just results in repeated warrants. All right, I think that's the last of it. Right one? I don't even know.
All right, okay, bye, dude. All right, turtle video. Now, with all of my previews, I always tell you guys this is going to be a release. This is actually planned for Monday, so I'm going to release this one on Monday, but I will play it for you guys today. All I ask is that you click on it and hit the like button. You don't have to rewatch it again. Just click the like button when it comes up. I will fast forward my intro so you don't have to watch it again. But yeah, that's all I ask when I release this on Monday, because on Monday I have my girls, or my kids. So it's been confirmed. I will not be streaming live on Monday night or Tuesday night. I should be back Wednesday night though. But I have pre-made release videos, so I'm still putting out content. But yeah, not going to be live Friday night not Friday, Monday night or Tuesday night, because I will have my kids. So that's another announcement. I probably should have said that earlier, not wait till the very end. But yeah, it's been confirmed. Monday and Tuesday night, no live. Okay. Emotional support turtle, Judge Simpson. Let's go.
5 management versus Olivia Bell.
Good afternoon, Your Honor. Robert Weiss appearing on behalf of Group 5.
Hello.
Simpson, I'm her daughter.
Okay.
And I handle a lot of stuff too.
I got you. All right. What's your?
My name is Wait, did you?
I know. A long time ago.
But I just handle a lot of my mother's business now, so.
All right. Your name is Olivia Bell?
Yes, sir.
All right. Very good. All right. I'll allow that to proceed in this way. And she was gonna pay 159 by the 29th of May. Did that get done, Mr. Weiss?
We did get a payment of 159 on May 3rd. We posted on May 30th, yes.
Okay, fantastic. That was one of the things that was supposed to happen.
Yeah.
Returned out to today. What do you have?
This entire video isn't about turtles. I guess I should have said that. Judge Simpson makes a funny line about halfway through this about an emotional support turtle. That's where this comes from. I've been telling everyone about this clip for a week, but I'm finally showing it to you guys. So yeah, the entire video is not about turtles at all. Judge Simpson just makes one funny line.
What is the current balance?
Okay. The amount we're showing is $1,054. It's comprised of a pet deposit fee, a $25 pet fee per month going back to October 2023, late fees of $325 and NSF fee of $60 plus court costs.
Okay, so in that I did not hear rent.
No, she's
she's fully subsidized.
She paid the $159 is her portion of the rent.
That's why we had that paid. Okay.
Yeah.
Oh, okay, so let me ask this. So why was the
I guess so. Did you get the I'm sorry.
I did, but I mean, we'd have to discuss the account.
Okay,
So
I'll
if
call
you're
back.
busy right now, I'll have you.
Thank you. Sorry, Your Honor, I was on another call.
All right. So I got 9 months of a pet fee.
Correct. It's in the lease.
Okay, it's in the lease, but my question is why am I dealing with it 9 months later?
Well, they were going back and forth as to whether or not this was an ESA animal. And she did not provide, this is a second dog. The first one had to be removed because it was deemed violent. It bit another tenant. So she got another dog. We asked her to comply with the ESA requirements back in October, and she has failed to do that. So that's why.
Dennis, I am so sorry. I meant to shout you out before I started playing this clip. I am so sorry that I almost missed this. 3 months, Daniel. Dennis, wrong D name. Dennis, thank you so much. I am glad you're here. I am playing this clip. You know what? I'm playing this clip just for you because you were late. And yeah, just for you. Thank you for the 3 months, Dennis. I appreciate it.
The pet fee of $225, there is a pet addendum to the lease. It's $25 a month plus a $200 pet deposit that she does owe. And it's deemed, rent for the lease.
So when did the first dog qualify?
The first
Yes.
dog qualified. It was
So then it was removed.
because it was a pit bull and it bit somebody. But the
Okay,
dog,
okay. All right, hold on. Okay, so that dog had to be removed. She gets another dog.
Correct. And that dog would have to qualify the same way as an ESA with the doctor's statement that is necessary and required. She has failed
Hold
to.
it, but here's what I'm trying to figure out. The doctor's statement had no bearing on the dog itself. It was as to Miss Bell, right? Is that right?
What?
Meaning.
Yes. The turtle joke started with a poll. I used to put a third option in every poll that I would do just as a joke. And it was a poll saying, I don't know. It was, what bonus clip do you guys want tonight? Do you want a sob sit or do you want a Karen? And that was the poll. But as the third option, I put turtles. All I said, like, I like turtles. You know, the meme from the early 2000s. I like turtles. So I put that in there, and that one won. That option won. So everyone's been joking about turtles ever since then. So yeah, when I heard Judge Simpson say all he did was one sentence that said something about turtles, and I figured this has to come up. This has to come up. I got to use this. Dennis, thank you so much for the $5 super chat. Sorry, I've been AWOL forever, so many lives, and thank you. No, thank you, Dennis. I appreciate it, and I'm just glad you're here. I'm glad you're here tonight. So thank you for your super chat.
Whether I got a Chihuahua or a Burmese mountain dog, doesn't matter what the dog is. It's just that Miss Bell needed the dog.
At that time, the first dog, yes. The question
Right.
is,
So hold on a second, Mr. Weiss. This is what I'm not understanding. That dog she has to get rid of, whatever the reason, doesn't matter. Then is a new dog that she gets. So my question is, other than the qualification of the dog, why would you need something new if it's the person who needed the dog?
okay, let me see if I can explain it to you, Your Honor.
Yeah, you're not going to. You're not going to explain it because you're wrong. I think everyone in the chat I think a lot of us have seen this clip already. It's old. I know it's old. It's about a week and a half old now. People in court played this video right when it came out. And I was a little jealous that she beat me to it, which is why I saved it for my days off clip. But yeah, birds aren't real. I love that channel. Is he still around? The guy that does that, does he still do those videos? I haven't checked back up on him. It's probably been a year since the last time I watched one of his videos. But he was hilarious. The birds aren't real guy.
Miss Bell's been there for a while. She had a heart condition back in 2017. She got the pit bull. She got the qualification for ESA, so there was no pet fee or pet deposit.
Correct.
Our policy is for any new dog, there would have to be the same justification. So she got a new dog, I think sometime in 2023. That dog would have to qualify.
But hold on a second.
Even the lady in the top right corner, I don't know who she is. She's not a part of this case. She's even shaking her head. She's like, that's not true. That is not true. That is not how that works. That's not how any of this works. We all understand that that's not how that works. If you qualify for an emotional support animal, you're not qualifying the animal, you're qualifying the person, not the animal. So her first animal was a pit bull. Her dog was a pit bull, and it was aggressive, so it was removed. Unfortunately, she had to get rid of the pit bull, and she got a different dog. She shouldn't have to requalify herself for a different dog. That's not how that works. They qualify the person.
You're not, as I understand what you're doing as a landlord, you're not qualifying the dog.
No, but the question is, since
No, hold on though. What you're doing is you're not qualifying the dog, you're qualifying the person to have the service animal.
well, what we're saying, Your Honor, is that at the time of the new dog, she would have to qualify again as the need of the dog. That was 6-7 years ago. How do we know that she still does need the dog? And her doctor refused to send in that qualification. Had that doctor sent in the qualification and filed the proper paperwork, yeah, we would have done it. But that doctor refused to do it. That's why we're here. I understand your problem, Your Honor.
My issue with that is if it's about the person, then why does it change when the dog changes?
Well,
It would seem to me that you would make her qualify every year, 2 years by having the doctor's notes and then to make sure that she still needs the dog.
not necessarily, Your Honor. At the time of the original, hang on, Your Honor. At the time of the first instance, she would have to qualify, and the dog would have to qualify. But
Well, no, but
the
what's not, the
circumstances
dog
may have
isn't
changed.
qualifying. You are not qualifying the dog.
Yeah,
I could go get any dog in the world, bring the dog there, as long as her doctor says she needs a service animal, you will then qualify her to have a service animal.
but her
She's the, no, Mr. Weiss, you're qualifying the tenant to have a service animal.
correct.
The
Okay.
service animal itself, in a lot of ways, doesn't matter. She
Correct.
could have had a service dog. She could have had a service turtle. That's what I'm gonna have. I'm gonna get a service turtle. Anyway,
There we go. There we go. I told you. I told you. This entire clip about a turtle was right there. He's gonna get a service turtle. He's gonna get a service turtle. All right. I'm gonna let yeah, we still have like 5 minutes left of this clip. I'm probably gonna have to pause it one more time. But there you go. He's gonna get a service turtle.
she could have whatever, as long as a doctor is saying this is what this person needs. So if the issue really was, once the dog no longer could be there, if the issue then was that it's the dog itself, then I could see that argument if she would have to qualify as being in need of a service animal every year. But she doesn't have to do that.
No.
She would be qualified as long as that other dog lived.
Okay, that is correct. However, if the dog is no longer there, we would need justification from the doctor that she still needs a service animal.
Yeah, but hold on, she didn't. Why? If that dog had stayed there, she
Yes.
wouldn't need to do anything.
Correct. However, since the dog is no longer there, she would have to
She
establish.
brought a substitute dog in.
Yeah. Okay. She brought a substitute dog in.
Yeah, the other
However,
dog's on vacation. Why? What? I don't. That doesn't make any sense, Mr. Weiss.
oh, I think it
just
does.
doesn't.
I think it does.
I mean, I don't get it. If it's her qualifying, she's qualified to be in need of a service animal. Until somebody says that changes, she's still qualified in need of a service animal.
Correct.
The one service animal something happens with, she gets a new service animal. I don't think I think it's going to be up to plaintiff to prove she's no longer in need. And
No.
I don't think you're going to be able to do that. And I don't think you can under your lease because she automatically qualifies, or she doesn't automatically qualify. She qualifies and she stays qualified to have a service animal.
See, that's where you and I disagree. I think at the time, I agree with you to the extent that the if the dog had still stayed there, she qualified back in 2017. Okay, the dog's no longer there. How do we know she's still, when she gets a replacement or a new dog, how do we know she still needs a service animal? That's why
We'll put the dog on the stand.
the dog uses sign language.
Yeah, but no, that's okay. Depending on what kind of dog it is, I can talk to it. We'll have it testify.
I wondered about that, Your Honor. But what we're saying is that why, just out of curiosity, why wouldn't the doctor certify that she still needs the service animal? That's where we are.
Oh, I cannot answer for a doctor and I'm not going to.
No, and the doctor hasn't answered or filled out the
He
form.
may have said,
She
why
doesn't
am I
need to.
doing this? She's already been qualified to need a service animal. I'm not signing another thing. you have no basis upon which to ask.
She never said.
That might be the reason.
Doctor never said that. She says,
But I don't know that. All right. So how much are these pet fees? How much of this?
All right. Emotional support animals and a support animal. Yes, those are two different things. Oh, my alarm to monetize my live tonight just went off. That means I'm going way over my time limit. We're at 1 hour and 45 minutes. Man, it's been a long live tonight. Anyways, yeah, they're two completely different things. I understand that. We're talking about an emotional support animal, not a support animal. It was stated at the beginning. So she doesn't have a trained animal. She doesn't have a handicap that I'm aware of where, she can't see or she can't hear. So she has a support animal to help her. We're not talking about that. We're talking about an emotional support animal. So that's where I think it's on the person, not the animal. So the animal needs to be qualified to be a support animal. To be an emotional support animal, you qualify the person. Now, a support animal, I would probably you have to do both. So I understand Judge Simpson's side. The attorney is probably just saying, the support, and I don't know. It's all a big mix-up. And I think Judge Simpson handles this well. They're having a formal hearing on it. We're about to hear the date. Part of me thinks it might have happened today, and I'm really worried about it because I didn't watch Judge Simpson today. I didn't watch any of his document. So, yeah. All right, let's keep going.
The amount that she owes is a pet fee.
She owes, looks like $425, including the pet deposit.
Okay, so $425.
So that's what this case is over. So the landlord is trying to get, since she got the new animal, they're charging her back charges. So they're going back months, and you've had this animal for this long, and they're putting up late fees on top of this. So this has nothing to do with rent. So this is a landlord-tenant case that has nothing to do with rent. And apparently they're trying to give her $1,000 bill for having this dog for 6 months and, not paying for it. That's what this case is over.
What she owes is that.
Yes.
What's the other? Is it a late fee because she didn't pay that?
In part, and there were 2 NSF fees totaling $60 and the court costs.
Okay, so the NSF fee she might need to pay. I don't know about those court costs. We'll have to figure that out because the bulk of what she's brought here for are not paying the pet fees and for not paying the pet fees and then the late fees that are incumbent upon that. All right. So
if you want to,
when do we want to have a trial?
What?
When do we want to have a trial? I'm ready to try it.
Because
this is going to be easy. Somebody's going to have to come in and explain to me why she has to pay these fees again.
Well, why don't you set it? You want me to bring the doctor and subpoena the doctor?
You can subpoena the doctor if that's what you want. I don't know that the privilege is going to be waived, but that's okay.
What's your pleasure, Your Honor?
Well, when can we try this?
You want to do it on a Friday?
No. Just
no.
That'll mess up Friday. We'll do it on Tuesday.
There's July 16th at 9 a.m.
July 16th at 9 a.m. in person.
Thank you, sir.
July
He's
16th.
gonna get the doctor. Is that what he said?
July 16th, 2024. At what time?
All right. We've hit that point of the night. I'm going to give my last comment on this video, but I'm going to let the rest of this video play out. I know, guys, I paused it a ton tonight. I'm partly sorry about it. Partly, I was just having fun hanging out with you guys. But, yeah, if I were this attorney, just, this isn't legal advice. I am not an attorney, especially not going to give legal advice to an attorney. I would try to get a different judge on this. Judge Simpson already seems like he's barely going to listen to what this attorney has to say. I would absolutely try to get a different judge. But yeah, we'll see. July 16th. Okay, so it wasn't today. We still have time. It's almost a month away. All right, that's a turtle video. Again, not really a turtle video, but I'm calling it a turtle video because of the one sentence he said. I'm going to get an emotional support turtle. I'm going to do that. Okay, I hope you guys have a great night. Thank you, everybody, for hanging out with me tonight. Thank you for all the super chats. Thank you for the membership milestones, the PayPals, the Cash Apps. You guys are awesome. You guys were very generous tonight. I appreciate it. I hope you guys have a great night. Tomorrow is Saturday, so I do not stream live Saturday night. I may do an early live. Depends on what I have. But I have to save a lot of content right now because Monday and Tuesday I'm not going to be live. I have my kids, and then the week after that Heather is going to be here. So I'm trying to, put some clips in a folder that are ready to release. This was one of them. So this is going to be released on probably Monday as an actual release and not a part of a live. But yeah, so over the next 2 weeks, I'm only going to be live probably 5 days. So get ready for it. Get ready for it. You're going to be in withdrawal by the time I get back. But it's going to be a good time. It's going to be a good time. All right. You guys all have a great night. I'm going to go to Discord. So let's go to Discord and hang out for a little bit. Yeah, that's all I got. Until next time. Bye.
What time, mate? What time, Emily?
Can we do it a little bit later? I have a court hearing in Davis. We do it like 10:30?
10 o'clock.
10 o'clock?
10 a.m. 10 a.m. on the 16th.
Okay.
All right?
All right.
What kind of dog is it?
A Chihuahua.
You have it's a Chihuahua?
A Chihuahua. I had a pit bull at first, and
so now you have a Chihuahua.
A Chihuahua, and all he do was stay in the house. All she does stay in the house with me and bark, 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 bark.
The doctor authorized her
No, I'm good. I'm good. Thank you, though.
All right.
No, I'm not laughing.
It's fun.
Well, when I said a Chihuahua, I had no idea you had a Chihuahua.
It's a Chihuahua.
He looked like Yo Quiero Taco Bell.
See? Okay. I'm not a big fan of small dogs because I lose them, but okay. Thank you. Thank you.
Kurt, can you call me after the hearing?
Pardon?
I wanted to have my manager call me after the hearing. He's on.
Okay, he will. All right. Thank you.
Have a nice weekend.